So we're here today and we're talking about the trademark infringement case, which has been brought by the US Olympic Committee against the company that owns and controls and operates the Prime energy drink, which is co-owned by Logan Paul. And the complaint that has been raised by the US Olympic Committee is that the Prime energy drink has been marketed using words and phrases and trademarks that are owned and controlled by the US Olympic Committee relating to the US Olympics. Um, and specifically, the complaint is that internet advertising and social media advertising of the Prime energy drink has been using trademarks that are exclusively owned and controlled by the US Olympic Committee. So this case gives rise to a couple of interesting things to think about. First, it will be interesting to see whether the US Olympic Committee is able to satisfy the test for trademark infringement under US law, specifically that the allegedly infringing sign and the trademark that's protected are sufficiently similar or identical to give rise to infringement. The second point that will potentially be interesting to assess or to consider will be whether there's any defense to the infringement. So Logan Paul and his company may say, for example, yes, the words like the Olympics and US Olympics are protected as trademarks, but when we marketed our products, we weren't using those words and phrases in a trademark sense because they actually advertised their product in conjunction with Kevin Durant, who was a US Olympian, and so they may say the references that we made were descriptive or referential in nature, and that's not trademark infringement. That's not use in bad faith. The third thing that's interesting about this particular case is obviously the Olympics only happens once every 4 years for 2 weeks. So there's a very short window where this infringement is going to take place. And the court proceedings that were issued in Colorado about this case were only issued a few days ago, 5 days, 6 days before the Olympics was due to start. So it will be interesting to see whether the Olympic Committee are going to try and get some sort of a court order on an emergency basis to get the infringement to stop before the Olympics starts, or whether they're going to try and assess what the damages are, assess what the profits are resulting from the infringement, and try and get compensation for that infringement after the fact. And I guess that leads me on to the sort of final interesting point about this case, which is that it's not just the Olympics Committee that has a vested interest in seeing this infringement being prevented. It's also the other partners, the other licensees, the other sponsors who have paid for perhaps exclusive use of the Olympic trademarks. And one of those licensees, one of those partners is Coca-Cola. So they're going to be saying, hey, we've paid to be able to market our product, Coca-Cola, with these trademarks, with these brands for partnership with the Olympics. We're really annoyed now that our investment has been diluted and our exclusivity in that space has been diluted because there's someone else, a competitor, someone else who's selling an energy drink, and they haven't paid. So there's going to be confusion, there's going to be brand dilution, and we've lost our sort of exclusivity in that space. So it's all happening very quickly, and it will be interesting to see what happens between now and Friday when the Olympics are due to start in Paris.